Kaishaho or something similar like that. Have you studied Shoho or Kaishaho or company law? Yes? Couple, most of you? Okay. I see. Yeah? No? Yes? Great. Then I can ask you all questions. No. I won't do that, but I'll let you. But you're free to speak up if you want. Also, Tominaga-san, who's our staff who's helping with the program, said she may take some pictures from the back at some point, but she won't show your faces. Or she'll try not to, unless you turn around when she's taking the picture. Then you may show your face. But anyway, we'll make this short. But I just wanted to give some idea of some of the things we talk about, and give an example from a company law or corporate law class. I teach a class called Comparative Corporate Law, where we compare corporate law of different countries and talk about differences in corporate governance and the way that we basically the law helps to control management of companies. So I was for many years a partner at an American law firm. Actually at two American law firms. First firm was O'Melveny and Myers, which is a big Los Angeles-based firm, and the second firm was Morrison and Forster, which is a big San Francisco-based law firm. And so one of the practice areas that I did was mergers and acquisitions, where you represent companies buying and selling themselves, buying other companies or selling themselves. The case I want to talk about involves one of the most famous lawsuits resulting out of a sale of a company in the United States. And it's a case that everybody studies in corporations law class. When we think about companies in the United States, we're really thinking about who is running the company, who has the legal responsibility. Well, it's the directors of the company, the board of directors of the company, in most cases. So most of the lawsuits involve the duties of the directors. There are a couple different types of duties, and they really fall into two categories. This is all on this handout that you have, by the way. And I also handed out a copy of the case that I'm going to spend most of the time talking about, although we don't have enough. I would usually do this in 90 minutes, and today we're going to try to do it in maybe 35 minutes. So I apologize if we don't get all of it. But anyway, there are two types of duties. One is the duty of care, and then the other is the duty of loyalty. Basically, and then there's some related duties for each of these. The duty of care is what it sounds like. It's that if you're a director, you have to perform your duties with an appropriate level of care. So you think about the word care, do care, sounds kind of like a negligence concept, right? To actually pay attention to what you're doing and do a good job. There are a couple subsets from this. One is the business judgment rule. That the courts quickly figured out that they don't know as much about running companies as the directors do. And they don't want third parties, shareholders, coming in and second guessing the decisions that the directors have made. So the courts have come up with something, again, called the business judgment rule, which means that they defer to the business judgment of the directors can make a good decision sometimes they make a bad decision, but as long as it's within their reasonable business judgment, the court will not find them liable, right? Otherwise, no one would want to be a director of a company, right? Every time you make a bad decision, or you make a decision that turns out badly, if you're liable to your shareholders, you know, if you're not going to take any risk, right? Be very, very careful to avoid risk, and we don't want that. We want directors to be taking prudent risks, right? Even though it doesn't always work out. There's some other related doctrines. One is this doctrine called waste of corporate assets, which basically just means throwing away money. I mean, you could have bought something for you know, $1 million, but instead you bought something worse for $2 million. I mean, it's someone offered to come and work for your company for $100,000 a year, and you said, no, I'll pay you $100 million a year. I mean, there are some cases where it's just such a bad decision that it's called a waste of corporate assets. And then there's a third set of duties which involve duties to monitor. The directors might not actually make a decision, but there might be somebody down inside the company who does something bad. And the directors say, we didn't know, you know, that wasn't our decision. We told the head of our legal department, make sure you have a good compliance program. And he told us, oh, I went and I got the compliance program from the best company and I copied it. I made a nice copy of it and we agreed, we sent it, we gave a copy to everybody, and so everybody knew they had to comply. And so when an employee does something bad, we're not responsible, right? Well, there's some cases in the US that say you really are responsible. They call it Caremark, because Caremark was the name of the company. Got in a lot of trouble where many of the employees were doing bad things, and the directors kind of closed their eyes and avoided knowing about it. Well, they were found liable, so that's another type of duty. The second category is duties of loyalty. Okay. Chujitsugimu, I guess, in Japanese. So what's a duty of loyalty, right? Duty of loyalty is where you have a conflict of interest, where your interest is different than the company's interest, right? It's when the CEO says, I think we should build a new factory on this piece of land that my brother owns, and my brother will sell it to us for $1 million. When there's another piece of land that is cheaper or better suited for the factory, right? That's the type of case where the company the directors are violating their duty of loyalty. So duty of loyalty, because it involves a conflict of interest, in the US we have some procedural tests where basically if there's a conflict of interest, the director discloses the conflict and then doesn't vote on the decision. Gives full disclosure to the other board members. You know, my brother owns this property. It's not that you can't hide it. You say, I think this is the best property for the factory, but it's my brother's property, so I don't want to be involved. I'll let the other directors make the decision. I'll leave the room. You guys talk about which land we should buy, and you make the decision. And if there's a full disclosure and I'm not involved in the decision, then it can be a valid decision to buy the brother's land. Duty of loyalty, we don't defer as much. So today I want to talk about duty of care and business judgment, which comes up in pretty much every decision that a board of directors is making. Yes?
What is the difference between the fiduciary duty and duty of care?
Well, these are fiduciary duties, yeah. These are types of fiduciary duties. Fiduciary duty is a more general term that would cover both.
Duty of loyalty?
Yeah, I think duty of loyalty. These come from the law of trust law originally. So I've got a couple pictures on the second page. There's a great case called Dodge v. Ford Motor Company, which I'll skip today. I won't say very much about it, except that it was a claim against Henry Ford early in the history of Ford Motor Company that he was basically taking much too long-term an approach. Henry Ford was famous for, he wanted to sell the cars at a cheap enough price so that everyone who worked in the factory could buy one of the cars. He created the middle class in the United States almost single-handedly with this strategy. He paid his workers more than he needed to pay them, and he sold the cars for less than he needed to sell them for, and he created this wonderful engine of consumers who could buy houses and cars that really helped the American economy throughout the 20th century. There was a claim by some of his shareholders challenging his activities, basically, that would have prevented him from building this factory that he ended up building, the River Rouge factory, where you would basically put in coal and raw materials on one end, and cars would come out the other end. It was totally vertically integrated, very expensive, but miraculous factory that he was able to build because the court gave him the discretion. They basically said, you're the directors of the company, and if you think that it makes more sense to build this factory, instead of giving the money back in dividends to the shareholders, you can do that. So this was, deferring to his business judgment. It's a good example. You look 100 years later, and Ford Motor Company still exists. It's still a successful company. It's one of the few automobile companies in the United States that has never been through bankruptcy, actually. General Motors and Chrysler have both effectively been through bankruptcy. Okay, so the second case is called Schlensky versus Wrigley. This is a great case. Are any of you baseball fans? Anyone know the Chicago Cubs? Right, Chicago Cubs fans. Okay. Well, this is a great case about the Chicago Cubs. I went to law school in the University of Chicago, and I was in law school in the mid to late 1980s. The Chicago Cubs, were a great baseball team in the early part of the 20th century, until 1945. What happened in 1945? They were in the World Series, and they had this famous incident where the tavern owner came into the stadium with his goat, his Yagi. The owner of the Cubs kicked him out. And that was basically, and as the tavern owner was leaving with the goat, apparently he cursed the Cubs. He said, "I put a curse on you. May you never be successful." And in fact, after that, the Cubs lost that World Series. And then they had a very, 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 very long period of time where they were a very bad team. So some people, here's a picture of the billy goat, actually. You can see. So some people think that the reason the Cubs were a bad team had to do with the billy goat. But actually, there was something else going on. After World War II, other teams realized that they could increase their revenues if they played the weekday games at night, right? Because most people who had the money to pay a nice price for a baseball ticket aren't students and aren't retired people, but they're actually working people who want to go to a baseball game after work. So other teams put lights on their stadiums so that they could play their baseball games at night. The Cubs did not. The Cubs, the owner of the Cubs, Mr. Wrigley, if you've heard of Wrigley Chewing Gum, he's a famous Chicago businessman. He liked watching baseball in the afternoon sun. It's wonderful to watch baseball at Wrigley Field in the afternoon sun, and it really was a nice sentimental gesture to want to watch baseball in the afternoon sun. But it had some negative consequences for the Cubs. If you look at the chart, in the pre-World War II period, the Chicago Cubs attendance was always higher than the national average. But by 1966, they were sort of at 40% of the national average, right? For full season attendance. Even after Wrigley sold the team, they were still running, 550,000 fans less than the national average. And this was largely because they were playing all of their weekday games in the afternoon. This had some other effects, of course. They couldn't get TV revenue. They couldn't get nearly the TV revenue that the other teams could get. And the team had a losing record. So Flensky was a shareholder of the company that owned the Cubs, and he sued. He said, this is a terrible decision, it's a bad business decision, and the lawsuit was in 1968. So this is fairly, in the middle of this period where the Cubs were doing badly. All the other teams had lights, all the other teams were doing better. The Cubs were the only ones who didn't, and they were doing worse. So, what do you think the court did in that case? Well, Mr. Wrigley came in and said, well, I think that if we had games at night, it would be bad for the neighborhood. There'd be drunk people coming, stumbling out of the stadium at 10:30 at night. They'd get in fights in the alleyways. They'd be, throwing beer cans, and it would be really bad for the neighborhood. It would reduce the value of the property that the stadium is. He had some, and I think it's a nice thing to have baseball during the day. And so the court said, well, that's your decision. You're the management of the team. The directors get to make the decision. That's within your business judgment, right? Very bad business judgment, but still within the business judgment. And so that's a good example of really how much discretion courts would give to management. Of course, what happened afterwards? You can look at the chart at the bottom of page 2. In 1988, the first year that they actually, Wrigley sold to the Tribune Company. Eventually they got the permits they needed, they put in the lights, and even the first year that they had the lights, their attendance was almost double what it had been 6 years earlier. And by 2008, wow, 3.3 million annual attendance, and they're 550,000 more attendance than the average, right? That's how big a difference it was, having lights and not having lights. Another example, Wrigley sold the team to the Tribune Company, owned the Chicago Tribune, for $20 million. Right? So Flensky, as a shareholder, maybe he owned 1%, I don't know. Maybe he got a couple, maybe he got $200,000 if he owned 1%, right? Tribune puts in lights, invests in the team. So 25 years later, Tribune sells for $900 million. Right? Wow. So evidence, after the fact evidence that this really was a bad business decision, but it was a decision within the business judgment of the management. So that's an example of how much discretion management gets to make bad decisions. So if you're a shareholder and there's a management that just makes a bad decision, you don't really have too much of a remedy, except what might your remedies be? Any ideas what you do if you own some shares in a company and you don't like the decision? You're Slensky and you don't like Wrigley's decision. What are you going to do? You sue him, you lose. So that's not an option. What else could you do? Well, any ideas? You leave. You exit. exit. That's what and they talk about voice and exit in democracy, right? When you're a shareholder, exit means you sell your shares, right? Never, if you don't think the management's going to do a good job, the easiest thing to do is sell your shares. There might be one other thing you can do. In the normal case, fire the management, right? Replace them. Get the shareholders, get other shareholders interested to boot them out. They make a bad decision. That's something that investors do all the time. They don't sue. Instead, they organize and they vote no at the shareholder meeting, or they write a letter to the management. They say, if you don't put the lights in, we're going to run an alternative slate of directors. So those are some remedies you would have. Okay. This brings us to Smithy Van Gorkum, which was in 1985. It's interesting that a lot of the interesting cases involving sales of companies in the U.S., a lot of the interesting law was in the 1980s. Just like a lot of the interesting cases in Japan on the rules around selling companies are from sort of 2003 to 2007, when there was a lot of hostile takeover activity in Japan. A lot of big companies being bought and sold. The live door trying to take over Fuji TV, UFJ Bank being acquired by Mitsubishi. All these things were going on in this period of 3 or 4 years. This was happening in the 1980s in the United States. And this case came out in the 1980s. Okay, you probably haven't had time to look at this. So let me just try to give you a quick summary of the facts. This is also a Chicago case. Just happens to be another case that comes from Chicago, although it is a Delaware company, of course. So it's an interpretation of Delaware law. This was, the company's called TransUnion, and it's a company that's in the leasing business. So it's kind of a finance-related business. It's leasing, I guess, rail cars or something like that. It has a long-time CEO, Jerome Van Gorkum is the CEO. And all these facts happened in 1980, basically. The company was doing okay, and Van Gorkum was basically nearing retirement age. He'd been running this company for many years, and nearing retirement age. And, they had a meeting in the summer, in July, where they sort of made a presentation to the board of directors about the next 5 years. And they talked about all sorts of issues the company had, how the revenue was going to grow. And they didn't talk about selling the company, importantly. Nobody was thinking about selling this company. And they didn't even discuss it. Until, on August 27th, I won't write down this timeline, you can see it on the sheet. On August 27th, the CFO brought up, CFO was Romans, he brought up the idea of a leveraged buyout, LBO. An LBO is basically where the management team borrows a lot of money, pays out the shareholders, and takes over the company, right? LBOs were starting to get very popular in the United States around this time. He mentioned the idea, Romans mentioned the idea a couple times. And he said that they had been looking at the numbers, and he thought that they could pay $50 to $60 a share. Okay, what happened? Van Gorkum didn't like this. Okay, first of all, Van Gorkum's about to retire. He's not going to participate in it. But second, Van Gorkum was He wasn't a public accountant, and he was a lawyer. So he's a CPA and a lawyer. Got a lot of knowledge. And he immediately realizes that in an LBO, there's a duty of loyalty problem, right? You're basically negotiating against yourself. You're trying to buy the company from your shareholders. Instead of doing a good job for your shareholders, you're trying to negotiate against your shareholders. So if you actually want to do an LBO, immediately a little red flag goes up and you say, well, time out. We have a duty of loyalty problem, and you need to come up with a process. Who's going to be on the shareholder side? Who's actually on the LBO team? Otherwise, you have a big problem. So Van Gorkum says, let's forget it. No LBO. I don't want this conflict of interest. Then he starts actually thinking about selling the company. He doesn't go and talk to the board of directors. He just on his own thinks, gee, maybe we should sell the company. Romans thinks we should do an LBO, but I'm the boss, I'm the one running the company, and I think we can probably do a better deal if we just sell the company. He goes and meets Jay Pritzker. Anybody heard the name Pritzker before? My son is about to go to medical school. He's going to go to the Pritzker School of Medicine at the University of Chicago. If you go to Northwestern School of Law in Chicago, it's the Pritzker School of Law. The Pritzkers started the Hyatt hotel chain. They're a very wealthy family, and Jay Pritzker was the guru. He was the person who made all the money. Penny Pritzker, his niece, was the Secretary of Commerce in the Obama administration. Actually, she's come to Japan a couple times. She's good friends. She was good friends with Carolyn Kennedy, so she wanted to come to Japan. So Van Gorkum goes and he talks to Pritzker. Pritzker does buyouts of companies. He's someone who buys and sells companies, and he actually takes something to Pritzker, and he tells Pritzker, the company, you can buy the company, it's worth $55 a share, right? And he says, but if we're going to offer the company to you for $55 a share, then if somebody else is willing to pay more, then we have to be able to accept that. I think $55 is a fair price, but if we can find a better price, then we have to take that, basically. So then things happen very quickly. If you look, this was all July, August, September. Now everything's happening day by day, basically. Once they get going, Pritzker gets back to him 2 days later, says, give me more information. I think I want to do this. They have a bunch of additional meetings. 3 days later, there's another meeting, and basically, they hammer out the terms. And Pritzker says TransUnion needs to accept his offer by Sunday night, right? This is on what day? On Friday, I guess, or on Thursday. So on September 18th, says you've got to accept the offer by the 21st. So you've got basically Friday and Saturday to think about it. Says, why does he say they need to accept it by Sunday night? Why do you think he doesn't want them to have until the next week to think about it?
Maybe market opens and then the price of shares change?
That's what he says. Yeah, he says, I don't want to be, I'm worried that the price might start to go haywire, right? It's a news leaks, and that's a valid reason why you might want to do it. And in fact, when companies are negotiating these deals, they do often try to get them done on a weekend. I can remember doing a deal for a public company where we all showed up in New York. We basically had a deal, in principle on what the terms would be. We all showed up on Thursday night. We worked until Saturday night, got all the documents done. By Sunday, they had their board meeting, and they had, and they were going and talking to the reporters, so it'd be in the newspaper Monday morning. They call it Merger Monday in the United States. We have Black Friday and Merger Monday because these deals do get announced on Mondays. But I think really what Pritzker was, what he had in mind to get this done quickly was to avoid competition, actually. He's a smart guy, and he realizes he's getting a good deal. And he didn't even need to negotiate, right? The CEO just came and gave him a price that was a low price. And he knows it's a good deal, and so he wants to grab it before anybody else hears about it. Because once somebody else hears about it, the price he pays is going to go up, probably. So I think that's actually what's going on there. So then they have, there's a lot of detail about the board meeting on the 20th, on Saturday morning. Nobody else knows what's going on except for Van Gorkum and one or two other people. They call the board in, basically, Van Gorkum gets together with Romans and the other managers, tells them what's going on, says we're going to sell the company to Pritzker, and we're going to have a board meeting now. And basically nobody likes it. The management team, they're very unhappy. Well, they may be unhappy because they wanted to buy the company. They may be unhappy because they don't like Jay Pritzker. They may be unhappy because they think it's a low deal. But anyway, they're unhappy. None of them support the deal. Then he goes to the board. They have, again, there's a lot of detail in here. And if you look at the decision, you'll see that in the US, these cases do have a lot of detail. They go into, down into the weeds, very, very careful description of the facts, because the facts are very, very important in figuring out whether they actually did their job or not. And basically, they have a meeting. Van Gorkum gives a presentation. They don't actually have a copy of the agreement for the board to review. Oops. And Pritzker's drafting the agreement. That's another bad fact here. And, basically, they have this quick meeting, some very experienced members of the board, 4 CEOs, the former dean of a business school, people who ought to know what they're doing. They come in, they hear this, and they agree to do the deal. In fact, there's an attorney at the meeting who tells them, if you don't agree to do this deal, your shareholders are going to sue you because you've deprived them of this wonderful opportunity. The stock price, of course, is $38 a share. And, so the shareholders are going to make a 50% profit, right? And if they lose that opportunity, maybe they're going to be unhappy. So the attorney says, if you don't approve the deal, you might get sued. Okay. And so this happens. There's a lot of things that happen afterwards that we don't have time to go into. And eventually, of course, the shareholders do approve the deal by a very high margin. The shareholders are happier to get $55 a share than to have the deal fall apart. So they vote yes. Okay. Meanwhile, there's some shareholders aren't happy, and they bring a lawsuit, right? And the question is, is this a case like Flensky v. Wrigley, where they made a bad decision, but the management's protected? Or did they even make a good decision? Maybe they actually made a good decision. The shareholders are happy, they voted for it. So should management be protected? Or does management have any exposure? Well, it's not a duty of loyalty problem, right? They decided not to do the LBO. Van Gorkum, he is a shareholder, so he's actually happy to get $55 for his shares. So that suggests he should be in protecting the shareholders, right? He's in the same position. So just a pure duty of care case. The question is, did they satisfy their business judgment, the business judgment rule, and is the court going to defer to the judgment of these very experienced directors? Well, if you look at the case, you'll see that the court thought there was a big problem. And the court actually found the directors liable in this case. This was a surprise when it happened. And that's why you see this case in every corporations law class in the United States. Because the court found liability for the directors. And we don't have time to go through it all, but I'll give you a couple of problems. Okay. Who has the obligation to sell the company? Who actually is in charge of this? It's not the CEO, it's the directors. They're the ones who should be running this process. They're the ones who should be happy. And they're the ones who should be organizing the process to sell the company. In fact, they didn't even know that there was a proposal to sell the company until, essentially right before the board meeting where they approved the sale. Okay. Second, they didn't even know how the price was determined. I think if they had asked Van Gorkum, clearly, where did the $55 come from? And he said, well, that's what I proposed to Pritzker. Then they would have said, oh my goodness, this is terrible. Why didn't you force him to come and make an offer? Maybe he would have offered 65. Maybe he would have come in and offered 70. But you never even asked him how much he was willing to pay. You just told him, you just guessed this number. So how do you know that that was a fair price? How do you know that you got a fair price for the company? Well, often you would hire a financial advisor. And this is something all the investment banks do is they represent companies, and they will come in and they will do a detailed financial analysis. They'll look at other deals, they'll look at all sorts of ways to value the company, and they will give you an opinion that this is a fair price. The transaction is fair from a financial point of view to the selling shareholders. These people didn't do that. They didn't get any financial advisor involved until much later, when the deal was in trouble, after it had been approved. Those are some of the reasons why there was a problem. I wrote some of them down here. Yeah. I guess, ultimately, this is the most important decision for the shareholders in the life of the company, right? Once the company is sold, they get their $55, they go home. If the company does really, really well, it doesn't matter to them because they're no longer associated with it. So the court is going to hold the directors to a higher standard. So that's really what this case stands for. Why? Okay, so play the devil's advocate for 2 minutes. Why is this a bad decision? Why did the court make a mistake here? Well, if you force companies to go out and get a fairness opinion before they do a deal like this, there's no legal requirement for a fairness opinion from an investment bank, but if you force them to do it, what will happen? What, in fact, has happened? Investment banks, any investment bank will give a fairness opinion to anybody, basically. And they'll always figure out a way to find the deal is fair, because they're getting paid to do it. And these are the people who are going to hire them for their next project. They're not really independent. They will always find a way to give a fairness opinion, is what experience tells us. And so maybe it doesn't actually help too much. Second, these board members, maybe they didn't talk about selling the company before, but they knew the company really well. They were all CEOs of other businesses or the former dean of a business school. They were experienced business people. And clearly they knew that this was they could see that it was a much better price than the way the market was valuing the company. So, so to hold them liable is kind of unfair to them. And second, and lastly, the shareholders supported it. Shareholders voted in favor of it. So maybe there was another deal out there at $57 or $65 that they didn't get, but certainly this was a good thing for the shareholders. And so maybe we should support it. So that's a look at this decision. I'll stop now. But if you have questions or comments, do you think it was a good decision? If it was a bad decision? I think it was actually a pretty good decision because it changed the way that management thinks about selling a company. They take it much more seriously now, and they try much harder to get the best price they can get. So I think it actually improved the way that U.S. companies are managed. But it certainly was a surprise at the time, and it was probably a big surprise to Mr. Van Gorkum that he ended up needing to pay a lot of money to his shareholders. So thank you very much.
If you have any questions,
So thank you very much for your attendance this morning, and I hope to see you soon, everybody. See you soon, either next September. Is it too late? Is it still possible? Or either next spring, or either next September. Thank you very much.